Welcome to You in the Law. This is a program presented by the Chicago Bar Association. I'm Barry L. Gordon, a member of the Chicago Bar, and I have my own practice in Chicago, Barry L. Gordon and Associates, and I practice in matrimonial law and personal injury. Today's show is most unusual. It's an important show because we're going to talk about an area that has been actually untouched. We're going to be talking about reactions, communications, responses, and how lawyers are involved in a divorce case react to a GAL or a child's rep or an attorney being appointed for the children. We'll first go into defining what a GAL is and how it's different than a child's rep or a child's attorney. We're going to be talking about the difference between all three and which one of those particular individuals can testify or be cross-examined, how they relate to the children, as well as the pros and cons of having one of them appointed in a matrimonial case. Today we have two experts in matrimonial law with us. We have with me to my right here, both of them actually are to my right, we have Mr. Bill Wigoda. Thank you for being here.
My pleasure.
And I have Miss Linda Jakubs. Thank you for being here.
My pleasure.
Now, Bill is a child's rep and a GAL and has been appointed by the Circuit Court of Cook County to fulfill that obligation. And Bill and Linda have been practicing in matrimonial law for a long time. They're going to give us a take on how, well, she's going to give us a take on how she counteracts a GAL's report that is negative to her client. And I have to admit, in researching this topic, there are many matters which I really was not aware of, and that is the pros and cons of having a GAL appointed. Those will be discussed as well as other matters with these participants. I thank both of you again for being here. So let's start with you, Bill. When did you first become involved in being a child's rep or a GAL, and why?
I first started becoming a guardian ad litem or child rep about 2005 after I got qualified by the Circuit Court of Cook County to receive such appointments, and I chose to become involved in working with children because I think it's a good thing to do. I think it helps the children because the children are generally the ones who are the big losers in parentage cases and in divorce cases. So I do my part to try and help them out.
Okay, and how did you get appointed to represent children?
Well, every courthouse, every circuit has different qualifications. In the Circuit Court of Cook County, you have to be certified or qualified, and you have to go through, I think it's a 6-hour, 8-hour course. You have to have trial experience, you have to have tried a number of cases, and you have to have a certain number of years of experience in domestic relations, and then you have to be passed upon by the Child Representative Committee, which is appointed by the presiding judge of the Domestic Relations Division.
Okay. Now, which one of you would like to answer what the difference between a child's representative is, an attorney for the child, or a GAL? Linda?
Well, I'll take a stab at all three, Barry. An attorney for the child is an attorney just like an attorney for an adult. That attorney is someone who advocates for that individual pursuant to that individual's desires. So just as an adult client would say, Mr. Lawyer, I want you to do this, you're my lawyer, this is my position, go fight for me. Be my squawk box, be my arm, my hired gun. That's an attorney for the child. And when we're talking an attorney for a child, it's usually someone who is more of a teenager who has the maturity to direct her or his own attorney to do something. Can be kind of a risky situation because anybody who has experienced teenagers knows that the teenagers might not really know what's in that teenager's best interest, even though that teenager says she wants something or he wants something. Now, a guardian ad litem does not even have to be an attorney. It can be a psychiatrist, psychologist, it can be a licensed social worker, it can be anyone who has been found by the court to be competent to represent the best interest of that minor. So even if that minor doesn't particularly desire what the GAL, the guardian ad litem, is espousing, that guardian ad litem, having made a full investigation on the matter at hand, the dispute at hand, will say, hey, this is not necessarily what my child, what my client wants, but as guardian ad litem, I say this is what is in this child's best interest. Now, we have what's called a child representative. That's a legal title, capital C, capital R. That's a hybrid of those two. So not strictly an attorney, not strictly a guardian ad litem, but the child representative must be, as Bill said, must be an attorney who is qualified in domestic relations, but also is given free rein, such as a guardian ad litem, to do a full investigation. Speak with anyone and examine anything that might be helpful for the court.
All right, Bill, which one of those two or all three have the duty of confidentiality?
Well, certainly an attorney for the child has a duty of confidentiality. A guardian ad litem does not have any duty of confidentiality. And with regard to a child representative, it's based upon the conversations with the children. I usually tell the children when I'm meeting with them that I want them to tell me what they don't want me to tell anybody else.
Okay, now one of those two, I would think, and maybe I'm wrong, looks at their client, being the child or children, objectively than the other one does. Is that a true statement or is that a fallacy?
What do you mean?
Well, what I mean is this, is that Linda indicated that the attorney representative, I think, talks to the children and usually represents older children. Is that correct?
It depends on the situation, but yes, that would be correct. You would not have an attorney for the child for an infant or preteen.
All right. Isn't there more camaraderie between a child's rep and the children?
I think so.
Okay.
And of course,
And the other then would look at the child or children more objectively.
certainly yes. The GAL, absolutely. The GAL can pretty much ignore what the child does or does not want. In fact, I've had situations where that occurred, and I've had situations where children have gotten angry at me because I've recommended certain things.
Okay. Now, Linda, can one of the three that you just described testify?
A guardian ad litem can testify.
But not the other two?
That is correct. A guardian ad litem can be cross-examined. A guardian ad litem is expected to prepare a written report of that guardian ad litem's investigations and opinions and findings. And the recommendation that the guardian ad litem makes is subject to cross-examination by mom's and dad's attorneys. It can be a rough position for the guardian ad litem, but an attorney for the child or a child representative submits neither a written report nor makes explicit recommendations, so that the position that a child representative takes is much more subtly conveyed. Isn't
That's
subtly
correct, right.
conveyed, so that the child representative doesn't get up and opine directly or make a conclusion or make a recommendation,
Okay.
if that's helpful.
Now, Bill, you've been in this position a long time. Do you have a preference as to which a GAL or a child's or attorney representative of the children you would prefer?
It really depends on the situation, but if I had to make a general statement, I would prefer to be a guardian ad litem, because then I can make reports to the court, and I don't have to make my recommendations, as Linda pointed out. I don't have to be subtle about it. And I certainly don't mind being cross-examined.
Okay. Can people hire you directly?
No, I have to be appointed by a judge of the Circuit Court of Cook County. The judge appoints me, or the attorneys, one or both of the attorneys will make a recommendation, but it ultimately has to be pursuant to a judge's order.
Now, may I interject with,
Please.
with something to follow up, a follow-up question? I'm a little bit surprised, actually, that Bill would say that he would prefer a guardian ad litem position, which puts him in a position of being cross-examined by mean mom's attorney. What about the lack of confidentiality with your minor? I say your minor, your client, wouldn't a child representative position at least give you the position of saying to your youngster, hey, anything that you relate to me is strictly confidential. You can't do that as a guardian ad litem, so don't you think that a guardian ad litem's relationship with his kid suffers as a result of that?
It's a good question.
It's a good question, and it's a balancing act. Okay, it really is, and I think, and maybe I'm being too egocentric, but I think I develop a good relationship with the young people who I represent, where they open up to me. For example, a lot of guardian ad litems or child reps have the children come to the office. As a general rule, I usually go to their homes, and I take them out for dinner, or I take them out to the park, and I develop a relationship with them. And very often, even as a GAL, if a child says to me, I want to tell you this, but I really don't want you to tell anybody.
Right.
Even if I'm a GAL, I will maintain that confidentiality.
Okay. Now, what special training, Bill, do you have to have, a continuing education or what, to become a child's representative?
Well, as I indicated, we have to go through a training course before we're qualified. And then after that, we have to go to at least, I can't remember if it's 3 or 4 classes per year. And the classes are offered by the Circuit Court of Cook County. They're once a month. They're in the Chief Judge's chambers, and they start at noon and they end at 12:30, and they do keep good attendance. And you don't, and you have to, and I can't remember if it was 3 or 4. I know it was 3 for a long time, and they were thinking of raising it to 4, which I think they should, and that's the requirement.
All right. Now, I know that for a fact that you have children, all grown. Right. Do you think that that should be a prerequisite?
I do not think it should be a prerequisite. I know some very fine child representatives who do not have children. I can say for certainty that having had children and now grandchildren and having gone through a divorce, that it has made me a better child representative because I've lived through it.
All right, Linda, you give me your answer.
I do not think that parenthood or grandparenthood should be a prerequisite for certification as a child representative, because a child representative, a guardian ad litem attorney for the child, we'll just call it child representative, has a very, very important duty of neutrality, and an individual who can operate in an unbiased, balanced, neutral state throughout litigation that can be very contentious. That person doesn't always have to be a parent. It's not something that comes into play quite so much, the identification of what it's like to raise a toddler or how stressful the parents' lives are during a divorce. You don't need to know that in order to be something of a ringmaster in a litigation.
Yes, actually, if you come in with a clean slate, you may be better off.
That's a good point there.
Not having any experiences.
That is a good point. And there is a certain degree of ringmaster or diplomatic sort of function that a child representative has to
Now, we're going to wind up this first section right now, and we're going to be back. I want the public out there to understand that we'll be back in about 5 minutes, and that'll be part 2. And we're going to be talking about the pros and cons a little further and a little deeper, and we'll even talk about whether I have children or not. So we'll see you in a couple of minutes.